Law without justice is a wound without cure, said by William Scott Downey. A very good morning to everyone present here. I consider myself to be highly privileged to invite our speaker for today, Honorable Justice Mr. Koratagiri Narasimhamurthy Phaneendra, our respected Dean Sir, Professor T.R. Subramania, our Director Sir, and my professors and my dear fellow mates to this guest lecture on the role of Lokayukta institution in public administration. I would now want to call upon Pranav from 5th semester BBA LLB to invoke God's presence by an invocation song.
हरि श्री गणपतये नमः मंगलमूर्ति शरण मम हरि श्री गणपतये नमः विद्यादायक बुद्धिप्रदायक आनन्दवरदा आत्मप्रकाश हरि श्री गणपतये नमः कर्म विदायक शुभ फलकारक आनन्दवरदा सिद्धि प्रदाता हरि श्री गणपतये नमः हरि श्री निनि सा 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 रे रे सा नि सा सा नि सा नि मनि प म प नि सा रे मा रे सा नि प हरि श्री निनि प प म म प प निनि प प म म प प म प रे रे म प नि सा रे सा 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 नि 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 प प म रे म प नि सा हरि श्री गणपतये नमः हरि श्री गणपतये नमः.
Thank you, Pranav, for blessing our ears. To begin this day, I humbly request our respected Dean, Professor T.R. Subramania, to address the gathering.
A very good morning to all of you present here. Respected teachers, dear students, today we have a guest in Sri Phaneendra. He is the President of Lokayukta, Karnataka state. And prior to this, he has served as a judge of the High Court of Karnataka. And before that, he was the Principal Secretary to the Law Department, Government of Karnataka. He is a wonderful person, very efficient, known to everyone. Sir, without taking much time, I just, on behalf of the university, on behalf of the Board of Management, and on behalf of our teachers and students, I welcome you, sir. On behalf of the university, I request our director to present the book of law. I also welcome all the teachers who are present here and you dear students. Please listen to what the honorable guest is saying today, and it will be of immense help when you go out of this institution and start practicing before the court of law. Once again, with best wishes.
Thank you, sir. So it gives me immense pleasure to introduce our speaker, Mr. Honorable Justice Mr. K.N. Phaneendra. Sir hails from an agricultural family in Koratagiri, Tumkur district. He has completed his primary and higher education along with his graduation in Tumkur, after which He pursued his law degree at Vidyodaya Law College, Tumkur. He enrolled as an advocate under the Karnataka State Bar Council in 1985. Sir has also tutored students of the same law college he graduated from. During the year 1998, he joined the judiciary as Select District Judge. He served as the District Session Judge at Bangalore during 1998 to 2002 and in Shimoga from 2002 to 2005. He was appointed as a Secretary to the Chief Justice of Karnataka High Court from July 2009 to September 2009. Sir has also been the Director at the Bangalore Mediation Center from October 2009 to February 2009. He has also rendered his services to the Government of Karnataka as a Principal Secretary Law, Justice and Human Rights from February 2012 to May 2013. He has continued his service by serving as the Principal District and Session Judge from May 2013 to October 2013. He later was elevated as the High Court Judge of Karnataka during 2013. He has not only participated in several seminars and conferences as a resource person at New Delhi and Bhubaneswar, he has also been recognized and honored with the Karnataka State Award in 2009 for having written judgments in the Kannada language. He has retired and demitted his office of the Karnataka High Court Judge on the 19th of May 2020. He has assumed the charge of Lokayukta for the state of Karnataka on the 29th of March 2022. To have a man with such vast knowledge of every area of law and with great expertise is truly our privilege. On that note, I kindly request our Speaker, Honorable Justice Mr. K.N. Phaneendra, to come and broaden our knowledge and understanding for today. Thank you.
Respected Dean of this college, Principal of this college, and all the faculty members, and my dear students. ಎಲ್ಲರಿಗೂ ನನ್ನ ನಮಸ್ಕಾರಗಳು. ನಾನು ಸಾಮಾನ್ಯಕ್ಕೆ ಎಲ್ಲೋದ್ರೂ ಕೂಡ ಕನ್ನಡದಲ್ಲೇ ಮಾತಾಡ್ತೀನಿ ಜಾಸ್ತಿ. I prefer to speak in Kannada, but the subject is like that, and I am addressing the law students, especially who have come from various other places to study here. To make them understand, today I prefer to speak in English, with the permission of all of you. When your Dean, Mr. Subramaniam, called me to have a lecture or a seminar like to this college students, I thought that on which subject I have to speak. When I assumed the charge as Lokayukta about 6 months back, I have rich experience with regard to the difficulties of the people and how best the law students can help the people to exercise their rights properly and have their rights accomplished through the courts of law and as well as with other institutions. Therefore, I selected the subject, that is, what is the role of Lokayukta in public administration. Prior to that, I want to say Mr. Subramaniam was very well known to me since long, as he was Vice Chancellor to Karnataka Law University when I was Principal Secretary to the government, Law Secretary to the government. He himself is an institution having a profound knowledge of law. Particularly, he is a master in international law. And he used to share all his lectures and other seminars and his notes and write-ups with me in WhatsApp. And I am in fact enriched with such knowledge through his commentaries on international law. So I am very thankful to Mr. Subramaniam to having provided me this opportunity to share a few of my thoughts with all of you. You see, Lokayukta institution, it's not a government institution. First of all, you must know that it is not a government institution. It is an independent institution. Rather, it ascertains the malpractices that takes place in the government. So prior to know about this institution, first we have to understand what is the real ambition of our Constitution. The two articles of the Constitution, one is Article 14 and 21 of the Constitution, which refers to right to life and right to liberty of persons. So these two are the, according to me, heart of the fundamental rights. So Article 14 says right to life. Life means what? Living in a particular country, not like a dog or a jackal, but living in a particular country with all dignity and respect. That is life, which is described by the Constitution and interpreted by various judgments of the Supreme Court. Article 21 refers to right to liberty. You are free to walk anywhere in your country, subject to certain reasonable restrictions. Like that way, life is also reasonable restrictions can be put by the constitutional machineries. So these two articles says that how the life should be in a particular country or in a state. So the affairs of the public should be maintained and managed by the governments, either the central government or the state government. Public administration, administer, that is the Latin word. Public means who is a public? We are all public. So all the citizens of that particular country or the publics of that particular country. And administer means manage the affairs. Manage the affairs of the public is nothing but public administration. Manage the public, manage the affairs of the public is nothing but public administration. So to achieve this public administration, what the governments would do, you know that there are three pillars of the Constitution. One is legislative body, and another is executive, and third one is judiciary. Fourth one, though we recognize it as a fourth pillar of the country, that is press and media. But as per the Constitution, these are the three pillars which takes care of this public administration actually. So the first, the central government or the state government, they will, welfare of the people of the country is the fundamental principal duty of the governments. Welfare of the people. Welfare of the people should be in accordance with rule of law. That is the public administration, how they administer the public, how they administer the public affairs. So how they manage this by means of these three institutions. If we understand this, then only we can come to know that what is the role of this Lokayukta institution. See, for the benefit of the public at large, as and when required, on need-based, the legislations will come out from the gates of Parliament and the legislatures, state legislatures. The laws are made, rules are framed, circulars are issued, guidelines have been issued by the government, state government or the central government for the purpose of welfare of the people and also to control the conduct of the people. So every law which is created of the Parliament or the legislature Either it should give a right to a particular person and create a liability. So adjudication of this right and liability is vested with the courts. So what is that right by means of legislation that has been given to the people? So those rights, right to acquire a property, right of liberty to walk anywhere in the country. So therefore, every substantive law gives rise to a substantive right to the public at large, citizens of the country, and correlatively, liability is also fixed on the public at large. They are the two faces of the same coin. I have a right, I have also a duty to respect the right of others. So once the right is created, by means of that right, he has to acquire something. He will be facilitated by the government. So for us to exercise that right and acquire what are the benefits that is arising out of that particular right. For example, a widow is entitled for a widow pension. A senior citizen is entitled for pension. So like this way, if that entitlement is covered by means of a right, that right can be exercised. Where it should be exercised and how that right should be protected or implemented, that is the duty of the executives. So whatever the law that has been introduced by the parliament or by the state legislatures, that implementation of that law is in the hands of the executives. If the executives doesn't work properly, then comes the role of the judiciary to protect that right or to enforce that right before the court of law. So every court of law has been invested with so much of powers. Not only exercising the right, power is given to the public at large. The court can grant the remedy, not only grant the remedy, but also it is invested with sanction. Sanction means enforceability. After a particular order is passed by the court, if the order is not followed, disobeyed, the court itself has got power to enforce that order and see that that order is complied by the concerned persons. That is the sanction behind the law, sanction behind the powers of the court. So this is one way how the governments want to administer the affairs of the people by means of giving rights to the people by means of legislations and giving powers to the executives for the purpose of implementing that particular law. If anything is violated, then judiciary comes into picture for the purpose of protection and enforcement of those laws. So now comes how this administration takes place. Administration means there should be a proper and correct administration by means of following rule of law, protection given to the rights of the people. So if there is any maladministration takes place, then the question of courts and as well as the institutions like Lokayukta will come into picture. As you might have studied in the law of torts, that three types of feasances are there. One is malfeasance, another is misfeasance, and third one is non-feasance. While the executives doing their work, they should do in accordance with law and there should not be any deliberate action in not providing the facility to the people as provided by various legislations and rules, guidelines and schemes framed by the governments. lot of schemes have been framed by the government. For example, construction of various tanks, reservoirs, and making various roads for the benefit of the people, whatever they do by means of introducing various schemes. That should be implemented in accordance with law by the executives. So in executing this, they will do some mistakes. That is malfeasance, misfeasance, not. That is, we can say that maladministration, misadministration, and non-administration. So once we understand this, what is meant by maladministration? Maladministration means doing an illegal act prohibited by law. An act prohibited by law, if an executive does that, that amounts to maladministration. What is misadministration means? Doing a legal act in an improper manner. For example, simply delaying tactics is applied, not providing the justice in time by the executives by providing the facility, making the people to run from pillar to post for to achieve his or accomplish his right, or demanding corruption, demanding money for that, or by any means, any other means, etc., etc. That is prohibited. That is misadministration. That is the doing the legal act. He will do that. He will do that particular act, but not as provided by law, that he will do it in delayed manner or for any other reasons. So non-feasance means not doing an act which is legally he is bound to do. First one is doing an act which is prohibited by law. Third one is not doing the act which is legally bound to do. So by means of three important aspects, the maladministration takes place. So once the maladministration takes place, who has to take care of this is the question. Who has to take care? Everybody cannot run to the court. You see, if a health point is there, or if ill health is there to a particular place, where he will go? He will go to a doctor. If any problem is there with regard to your property, or if anybody assaults you, or if any criminal act taken place against you, where you will go? You will go to police. So normally the people who may not be in a position to afford to go to the courts, they will normally approach these executives first. The executives are nothing but they have to exercise their powers in accordance with the rule of law. If they don't do that by means of doing this malpractice, that is maladministration, misadministration, or non-administration, somebody has to take care of this. That there comes the role of the Lokayukta institution. Prior to 1984, a committee was formed where former Prime Minister of India, Morarji Desai, was the chairman of that. This concept of Lokpal and Lokayukta institutions have been evolved by that committee. And Lokpal is with reference to the central government, and the Lokayukta is with reference to the state governments. See, in the year 1984, the Karnataka Lokayukta Act came into existence. The role of Lokayukta is multifarious. We can divide it into several parts. One is grievance ascertainment and grievance redressal. That again it can be divided into two parts. One is public grievance and another is private grievance. The next one is very important. that is eradication of this corruption or prevention of corruption. Rather, it is eradication is nowadays it is hardly very difficult. Eradication can only takes place only after total destruction of the whole world. When reconstruction takes place. Otherwise, it is very difficult nowadays to repair it. It has gone to the extent of irreparable stage. So, as far as possible, these institutions are constituted for the purpose of hearing the public grievances and redressing the same as far as possible. And as far as possible, they prevent the corruption or try to eradicate corruption. These are the main functions of Lokayukta. How this Lokayukta institution functions? So, what is public grievance? What is private grievance? You all might have known that public interest litigations are filed before the High Court and the Supreme Court. Public interest must be involved there. Here also the same principle is applicable. There should be some public interest in making a complaint before the Lokayukta. So public grievance, everybody can file the public grievance. He need not belong to that particular area or locality. He need not use that particular road or any public property. But if you find that there is any malpractice or mispractice or the non-administration with regard to such public property, anybody can bring it to the notice of Lokayukta or Upalokayukta, as the case may be. Then the cognizance will be taken of that particular aspect and notices will be given to the parties and as well as to the delinquent officer who has actually committed that malpractice or maladministration. Then he has to come and explain. For example, if a road is constructed with a substandard quality or substandard material, in your locality a road is constructed or road is laid with a substandard quality materials, where you have to approach. You may approach the competent authorities on the side of the government. They may not take any quick action. Then who has to monitor this? Who has to, if those things cannot be achieved by means of governmental authorities, there should be somebody should be there to monitor their conduct, monitor their activities of the government executives, including the chief minister and ministers, MLAs, MLCs, etc., etc. Everybody comes under the umbrella of Lokayukta and Upalokayukta institution. So what is the remedy? If a public grievance is complained before the Lokayukta or Upalokayukta, we have got sufficient staff and experts in our department. We are provided with engineering division, police division, and also the Lokayukta Act provides the Lokayukta or Upalokayukta can take the assistance of any person, can take the assistance of any official, any expert for that purpose. Then what the Lokayukta or Upalokayukta will do, that they will appoint an engineer or an expert for the purpose of ascertaining whether the road is laid with substandard work. If it found that it is substandard road or substandard materials are used, then we will initiate disciplinary proceedings against that government official. And we will make a request to the government that there is a prima facie material to proceed against that man to conduct a departmental inquiry. And government normally will not say no when the Lokayukta or Upalokayukta recommend for a disciplinary inquiry.
Sir, I have a question.
At the end, you can put any questions. I will answer. Let me complete this. Another 15-20 minutes. I will conclude. I will open to you all to put because it is so. I thought that without even explaining anything, we can start with the interaction. But first, you should know what is the institution, functions of the institution, and then only you can put some questions. So therefore, then he will come before the authorities, and the government will entrust the matter to the Lokayukta institution for to conduct the disciplinary inquiry. And after disciplinary inquiry, if we found that there is a dereliction of duty by that officer, we will recommend for punishment also. We will give finding with regard to his misconduct, and as well as punishment of removal from service, suspension, and then termination, and or by means of cutting 2 or 3 increments, etc., etc., depending upon the gravity of the misconduct that person has committed. The same procedure is also adopted so far as private grievance is concerned. Private means it is applicable to only individual person or a group of persons. It is not compared to public grievance. It is something different. It is applicable to only some group or a particular individual. As I told you, if a pension is not given, salaries are not released, even after retirement benefits are not given. It's an individual's grievance. So individual will come, and totally you have to understand that a complaint should be against a public servant or a government servant. Who is a public servant? Who is a government servant? Again, all government servants are public servants, or public servants may not be government servants. For example, corporation has got independent control over its employees. So therefore, though he may not be directly called as a government servant, nevertheless he is a public servant. So therefore, all government servants are public servants, but all public servants may not be government servants. So there should be a complaint against a public servant. Then only the Lokayukta gets jurisdiction to inquire into the matter. So next stage is with regard to corruption. Prevention of Corruption Act. It is a very vast enactment and very powerful enactment. But nowadays, by means of some amendments to the Prevention of Corruption Act, to some extent the rigor is diluted. The rigor of the act is a little bit diluted by means of introducing particularly section 17A of Prevention of Corruption Act, where any action should be taken against a public servant. The previous sanction or permission of the government is necessary. So this is very difficult for the investigating agency to obtain permission from the government to take action against the government servant. So this is going on. The next important aspect one should know is that the Lokayukta or Upalokayukta or the persons who are selected from the higher judiciary, the person who is having experience of more than 10 years as a High Court judge, he will be selected as Lokayukta, and the person who has minimum service of 5 years in the High Court as a judge, he will be selected as Upalokayukta. The jurisdiction is bifurcated. All the persons who have the basic salary of 76,000 and below, all those public servants will come under the jurisdiction of Upalokayukta. And above, all will come to the jurisdiction of Lokayukta, including Chief Minister, Ministers, MLA, MLCs, etc., etc., IPS, IAS officers, etc. So therefore, the rights and duties of Lokayukta and Upalokayukta are earmarked, and there is no clumsy in that particular area. So Lokayukta and Upalokayukta, they have the power of sumo motu initiation of the complaints on the basis of paper notifications or by means of these media news. On that basis itself, the sumo motu action can also be taken. But rarely so far as private grievances are concerned, normally the sumo motu action is not taken. But public grievances where arises, then it comes to the knowledge of Lokayukta or Upalokayukta. Definitely a sumo motu action can be taken, initiated, and grievances can be redressed. The first and foremost important aspect is that redressal of grievance to the public at large, and thereafter the disciplinary inquiry against the delinquent employees of the government or the public servants. So these are all the important major factors. So this, as you know, that the Constitution, as I told you, that right to liberty and right to life. So in order to achieve or facilitate the citizens of the country, public at large, these three wings are there, and by means of these three wings, public affairs are maintained by the government. As I told you, lot of facilities have been given by the government, lot of schemes have been formulated by the government nowadays for the purpose of the benefit of the poor people. For example, farmers, or wherever these extremities takes place, the natural events takes place, calamities takes place. In such circumstances, the government will introduce so many schemes that has to be implemented by the executives, as I told you. If not, then only the Lokayukta institution will come into picture. So far as corruption is concerned, again, the sumo motu action can be taken by the Lokayukta, but Lokayukta itself cannot investigate into the matter so far as the criminal acts are concerned. That is why I have told you that we have a separate police wing. If any complaint is lodged either before the Lokayukta or before the Upalokayukta or before Lokayukta police, now ACB is completely removed and it is merged with Lokayukta police now. Government has to yet to pass some orders in this regard, providing all facilities and as well as the police officers to the Lokayukta. But nevertheless, the High Court verdict is that the ACB is completely cancelled, and now all the work that has been entrusted to ACB has to be conducted by Lokayukta police only. If a complaint is given, the police will investigate into the matter and file a report to the court directly. The judiciary has constituted various special courts for the purpose of conducting this prevention of corruption cases. They are called as special courts. So if a charge sheet is filed before the court of law or any report is filed, invariably, whether it is a charge sheet making allegation against the person as proved allegations or any B report is filed, nevertheless, on the basis of such report, a disciplinary inquiry also will be initiated against that DGO or delinquent employee. And as I told you, that procedure will be followed, opportunity will be given to both the parties, including the delinquent employee. And then trial will be conducted by the Lokayukta office. We have for that about 30 judicial officers, retired district judges and serving district judges, civil judge, senior division and junior division. The posts are created and they are all working there. They conduct the departmental inquiry. Ultimately, the recommendation will be sent either by the Lokayukta or by the Upalokayukta, as the case may be. So this is how the right of a person is not only protected and enforceable before the courts of law, but also redressal can be claimed before the Lokayukta. But we cannot punish anybody. We can only recommend for punishment. It is a recommendatory body. But once the disciplinary inquiry is initiated, the public servant will come to know that the consequences will be very severe, that he may lose his job. And contrary to that, if it is a corruption case, he will be prosecuted before the court of law. So therefore, in this manner, the Lokayukta institution, the mechanism will work. As I told you that the Lokayukta institution is constituted for the purpose of monitoring the maladministration by the governments, state government or the central government. It is a Lokpal will come into picture. My dear friends, why I am addressing this to law students? Wherever you go as in order to help the Legal Services Authority to conduct legal awareness programs, or your neighbors, any problem is there, any public grievance or private grievances are there. For example, I was telling my friend Mr. Subramaniam that even an application is filed for change of kata on the basis of this heirship. That is, legal representatives have filed an application for change of kata before the revenue authorities. You see, once the father is dead, automatically the property should be transferred, or kata or other things, property should be changed in the name of legal representatives. Unless there is any dispute between the legal representatives or any other objections are there, it should be automatic. Or if there are any objections are filed, then competent authority has to pass appropriate orders in accordance with law, which is, we call it as quasi-judicial order. So if the officer demands for any corruption, or if he delays in changing the kata, making the person to visit the office, so there arises dereliction of duty. In such circumstances, it should be brought to the notice of the Lokayukta so that immediate action can be taken. And we can ask that man, why you are keeping this matter pending? Either you have to pass an order, reject the application, or immediately allow the application and change the kata. Like that, we have various schemes I have told you introduced. For example, senior citizens' rights, family pensions, and widow pension, etc., etc. For that, they will make delay because of the reason the party has to go and contact them. And there arises the corruption process. So in order to avoid this, law students' duty is that at least you should create an awareness in the public at large. Such an institution is there. Some grievance is available or redressal is available if for every grievance against a public servant. They can make an application. So as I told you that after taking charge, I have various cases which have been settled immediately after even issuing notice to the government servant, public servants. Once the notice is issued, rarely we come across adamant officers. Normally, if notice goes from the Lokayukta, they will come forward to redress the grievance, if it is a legal grievance. Otherwise, we will ask them to pass appropriate orders so that the party can go up in appeal or to file appropriate case before the civil court or before the high court. So therefore, it is your responsibility to see that the public's grievances are properly addressed and by means of creating awareness amongst the people. the laws are made for the benefit of the people at large. All the schemes of the government have been introduced for the public benefit. That is, I told you, public welfare according to rule of law. So, this is exactly what I want to say about the Lokayukta institution and how it actually developed right from 1984. So we can keep it open to the students to interact in this regard. Yes, and thereafter I will conclude.
Yeah, so can I
Yeah, please.
Sir? So first of all, thank you.
Mic idhar kode.
I'm loud.
Yeah,
Can I start, sir?
you are audible.
Yeah, thank you, sir. Due to my medical reason, immediately I'll not get up, so my
No
pardon
problem.
on that. I'll sit and I'll ask the question. First of all, thank you for addressing us all students who have taken immense interest in law. I'll not go too detailed here there, and I'll directly jump on my question. And I pardon my ignorance that I'm very new to this concept of Lokayukta. Recently, I heard in news, and I was surprised as well when couple of respected MLAs were named or tagged as bulldozer Baba for breaking the buildings and other stuff which was needed for the betterment of the community. And during this my ride, I happened to get into a place, Dodanakundi. It is in Marathalli, and I have seen this area from last 10 years, sir. And the irony here is that at least 500 odd people are living there, and I don't know what is the issue with the government bodies there who are connected with that particular area's betterment. There is a big time drainage which is not related to Raju Kalve by any means, but the entire water just getting to that particular the area, and everything just floods there. So when I entered accidentally during a very heavy rainfall, I literally had to take my kiddo on my shoulder to cross and go to my destination where I was looking. That put me into a situation that what exactly is going wrong with that area. And to my knowledge, I got to know that there was municipal complaint gone in, there are BBMP complaints gone in, and there are a lot of the fourth pillar, what you just said, sir, that media is the fourth pillar, though it is not called it out. Even they have reported it on TV9. But then the question is that if so many things is happening from last 10 years, is it time for Lokayukta to pitch in to see what exactly is happening? If so, to your one point that you mentioned that being a law student, I'm sure not only law student, it is a responsibility of all the people of our country to public grievance, even anyone can file. So after your the guest lecture, what I'm thinking now, I should go ahead and I will certainly put a grievance, a public notice I'll file to protect this particular area. I'm nowhere related to this place. It just accidentally, accidentally I reached that place. So thank you for bringing that detail to all of us. That way, I think some contribution all of us can do for the betterment of our society.
So answer to this question is I did not go in detail with regard to the what type of applications can be filed, what type of complaints cannot be filed. The Act itself describes under Section 8 and 9 which are the cases you cannot file it before the Lokayukta. So where the case is already taken cognizance by the courts of law, then the Lokayukta simultaneously, parallelly cannot take up that matter. So here, your grievance is already taken up by the High Court. The writ petition by way of public interest litigation is already pending before the High Court, and High Court has already directed the BBMP to file report 15 days once. What is the cause for that? And secondly, another important aspect is with regard to this demolition of illegal structures. That is also pending before the High Court now by way of public interest litigation. So once the court has taken cognizance, parallelly we cannot conduct any investigation. So therefore, once where the court is not seized of any matter, such type of grievances can be taken up by the Lokayukta and conduct the disciplinary inquiry. So redressal means we can only direct that particular person why he has not done and why his duties have not been properly exercised. Right? So for other things, for enforceability, again court of law has to be approached. So we can only take action against such persons who conduct dereliction of duty. The main cause is that. Redressal in the way of directing them, that why you have not done, legally you are bound to do this, why you have not done, then he will redress that grievance. In that line only we can indulge in public affairs or public administration. When a party has to approach a court of law or already approached court of law, such matters will not come before the Lokayukta because there is a specific bar under section 8 and 9 of the Lokayukta Act. Another example I will give you that you have made an application to a Tahsildar for change of khata or for any other reason, where he has got competency to pass appropriate orders on your application, either means of granting application or by means of rejecting application. We can only monitor that why he has not passed any orders on your application. But we cannot pass any orders on your application directly because competency is vested with the concerned officer. So if he passes an order, you have to approach the appellate court for your redressal. You cannot approach Lokayukta because there is wherever appealable order is there, appellate court has got jurisdiction. So we can only control or we can have the cognizance why he has not passed any orders on your application. So if he passes an order, it will go in your favor, therefore he is not passing orders as early as possible. So such type of grievances can be taken up by the Lokayukta where the courts have got jurisdiction. For example, the brothers have got a dispute with regard to their family properties. Who is entitled for how much share? That cannot be decided by Lokayukta because it is the exclusive domain of the court. Wherever the party has to approach the court, he has to approach for these remedies because substantial laws provides remedy before the court of law. So where the public servants, that's why I told you that three important aspects, the maladministration, misadministration and non-administration. If it comes within these corners of three aspects, then only we can take appropriate action in that regard. You see, if the matter is not pending before any court, you can lodge a complaint to address the grievance because this is already pending. There are 2 PILs are pending. You might have read in the newspapers. Yes, any other question, please? Yeah.
Sir, I don't know whether I'm eligible to ask this question.
Oh.
Sir, you already mentioned that the very, the creation of Lokayukta is for monitoring the administration of government or executive. So I don't know like how far it is feasible because the Lokayukta and Lokayukta are appointed by the governor in case of state and in case of center it is president. So they are part of executives and on the recommendation of select committee in which executives are part of it. So do we need any reformation regarding appointments, sir?
No, not necessary. It is not a government. It is the appointment by the governor on the recommendation of a committee. Committee consisting of Chief Justice of High Court of Karnataka also. So it is not the appointment by the government, but it is appointed by a separate committee constituted on the basis of the Morarji Desai's recommendation. So that's why I told you that Lokayukta institution is not a government. It doesn't come under the purview of the government at all. Yes?
Good morning, sir. So I just have a small doubt or something. So being a common man, if
Mic ಇಲ್ವಾ? ಹ್ಯಾಂಡ್ ಮೈಕ್ ಇಲ್ಲ? ಓಕೆ ಓಕೆ,
so
ಮುಂದೆ ಬನ್ನಿ.
so being a common man, if at all we are threatened by any of the public officials, for example, like, since you told Lokayukta governs all the ministers, MLAs, and everyone comes under that jurisdiction. So, if a common man is being threatened by any of those, like misusing of their powers, the common man, can they approach the Lokayukta?
Oh, definitely.
And what will be the scope of Lokayukta in this?
That's why I told you that there must be some prima facie material to take cognizance. So whether you have recorded the conversation or in presence of anybody that scolding has been taken place, threatening has been taken place. So if there is some material is there, we will make a preliminary investigation after you lodge a complaint. What we will do, if you have no sufficient material, suppose, then we will request our police wing to investigate into the matter and file a report to us, so that you can give what materials you have got, what evidence you have got, so far as that aspect is concerned. On the basis of that, our police wing will give a report to us. On the basis of that report, we will recommend to the government that this maladministration has been taken place, that he has misused his powers, therefore action should be taken against him, that he should be removed from that post, or the entrustment should be made for to conduct the disciplinary inquiry. Thereafter, we will issue notice to that man and conduct the inquiry. If ultimately you will call upon you also to give evidence and also whatever the material you have got, and we will give opportunity to that man to counter that, and on overall analysis of the material, that our officer will give a report that misconduct is there or not. If there is any misconduct, we will recommend for punishment also, for removal him from service, as I told you, or cut off 2 increments with cumulative effect, or compulsory retirement, like that. Okay.
So, good morning, sir. ನಾನು ಒಂದು ಟೀಚರ್ allegations found ಬಂದಿತ್ತು, but whereas she was innocent, but a false departmental inquiry is initiated against her, where we took the matter before the ministry also. Ministry also has directed the additional commissioner education for the inquiry, but till date it is not implemented. What can I do for that?
ಎಲ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಇನಿಷಿಯೇಟ್ ಆಗಿದೆ ಆಗಲೇ?
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಅಂತ ಮಿನಿಸ್ಟ್ರಿ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದೆ, ಬಟ್ ಆದರೂ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತಾ ಇಲ್ಲ. You can give application to us. Then we will call upon them why that has not been done.
Yeah, ministry has directed for the directions that if any irregularities are taken against that teacher.
Correct. Either they have to conduct the disciplinary inquiry or to close it.
Yes.
They have 2 options. One is either they have to drop the proceedings as no materials are available, no grounds are available, or if sufficient materials are available, they should proceed with the departmental inquiry and conclude it. We can ask them why they are not doing that. You can make an application that we will inquire into and direct them to proceed with the disciplinary inquiry as early as possible.
Yes.
Yeah.
But whereas one report has been filed by the concerned authority that there is no irregularities found by the teacher, but the higher authority who has framed the allegations against her found to be default. It is then false.
No, that is their domain. They can do that. Appellate authority can frame charges and proceed with the. But what we can monitor is that why they are not doing that in a proper manner, in a speedy manner. That's all we can. You see, either they have to pass appropriate orders in accordance with law by dropping the proceedings or concluding the departmental inquiry. Why they are not doing that, we can ask them. Do like this, do like that. No, we cannot say like that.
Thank you.
Okay. Yeah.
Sir, can Lokayukta take so much of cognizance?
Yeah.
Not one. They can.
Yet.
Sir, I have another doubt. So, you said that the Lokayukta supervises the other departments that they're working accordingly. So, basically, this mechanism is there in every department. Does Lokayukta stand apart by having a time frame to do something?
Well, that I did not catch your point.
So you said that the Lokayukta has a supervisory role with respect to issues that arise in other departments. That mechanism.
Somebody should complain, or it should come to our knowledge.
Yes,
That we cannot supervise every department every day.
Yes, sir.
Whenever any act falls within these three aspects, that maladministration, misadministration, non-administration, either it should be brought to the notice of the Lokayukta by any complaint, by means of any complaint, or suo motu it has come to its knowledge and taken action. Then only we can proceed. Otherwise, we cannot supervise all the departments every day.
Sir, but this mechanism mostly exists in most of the departments. So does Lokayukta stand apart by having a time period? Like Lokayukta is supposed to take action within 30 days or within 60 days?
The such limitations are not there. As early as possible.
So may I ask one more
Yeah.
question? So to her point, let's say that there is a PIL already existing for the given case of mine. It could be like it's been 10 years that I am seeing this. Now, for sure, there is the file is not moving, right? That is what it appears to be. Like the given scenario, what I just mentioned.
Where file is not moving before the High Court?
No, not the High Court. Like when I say BBMP and other areas, department who are handling, so they are aware of the situation, isn't it? And if those guys are still not able to do it, that point of time, can't Lokayukta question them that what is ailing you from last 10 years to not take action?
That's definitely.
That can be complained, isn't it, sir?
That can be complained. See, when the matter is pending before the High Court, those files we cannot touch upon. Please understand. Those files we cannot touch upon if it is connected with that PIL. Because they are directly answerable to the court. Periodically the court will take account from them. When it is seized off before the High Court or any other court, we cannot touch upon that matter. Yes, any other question? It's good you are all very actively interacting. I need some more persons to participate because it is a new thing you have learned now about the Lokayukta institution. That is what I found, though this act came into existence in the year 1984. Awareness, we are lacking in creating so much of awareness in the people, much less to the law students. Now we have started creating awareness, first amongst the law students. They should know one institution is there like this. Yes. So shall we conclude, sir? That's very important. You see this, I told you that corruption is rampant nowadays. And it has reached to the stage of irreparable stage. Therefore, the law students now, you are the budding lawyers, budding politicians, and you may become anything in future. But you should know that you are a law-abiding citizen. Apart from an ordinary man, a lot of responsibility is upon you to save the society from this corruption. First, we should be clean, and then only we can start cleaning others. Therefore, I want some oath from all of you that whatever the profession you choose in your life later, whatever you want to become, you become. But wherever you are, however you are, whatever you are, you take a pledge today that I will be honest throughout my life. I will not become corrupt. I will not yield to any influence during discharge of my duties as a citizen of the country. Whether that assurance, Swami Vivekananda one kade ಹೇಳ್ತಾರೆ, ನೀನು ದೇಶ ನಿನಗೇನು ಕೊಡ್ತು ಅಂತ ಕೇಳ್ತೀಯ. ದೇಶಕ್ಕೆ ನೀನೇನು ಕೊಟ್ಟೆ, ದೇಶಕ್ಕೆ ನೀನೇನು ಕೊಡಬಲ್ಲೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನಾನು ಅದಕ್ಕೆ ಹೇಳೋದು, ಏನು ಕೊಡದೇ ಇದ್ರೂ ಬೇಡ ದೇಶಕ್ಕೆ, ನಾನು ಎಲ್ಲೇ ಇರಲಿ ಹೇಗೆ ಇರಲಿ ಪ್ರಾಮಾಣಿಕವಾಗಿರ್ತೀನಿ, ಆ ಪ್ರಾಮಾಣಿಕತೆಯನ್ನು ದೇಶಕ್ಕೋಸ್ಕರ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಸಾಕು. ಎಷ್ಟು ಜನ ಇದರಲ್ಲಿ ನಾವು ನೂರಾರು ಜನ ಇದ್ದೀರಾ, ಇದರೊಳಗೆ ಎಷ್ಟು ಜನ ನನಗೆ 10 ಜನ ಪರಿವರ್ತನೆ ಆದರೆ ಎಷ್ಟೋ ಅಚೀವ್ ಮಾಡೋದಕ್ಕಾಗುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ ವಿತ್ ಆಲ್ ಹೋಪ್ ಐ ಟ್ರಸ್ಟ್ ಆ್ಯಂಡ್ ಹೋಪ್ ದಟ್ ಆಲ್ ಆಫ್ ಯು at least who are here, that you will take a pledge that throughout your life you will be honest to your country. You will become an honest citizen of the country. Can you give that pledge? Raise your hands. Thank you. You are taking this oath today. You must remember it throughout your life. You should not first become corrupt. ಕರಪ್ಷನ್ ಅಂದರೆ ದುಡ್ಡೇ ತಗೋಬೇಕು ಅಂತಿಲ್ಲ, ಯಾವ ಥರನೂ ಕರಪ್ಟ್ ಆಗಬಾರ್ದು ಲೈಫಲ್ಲಿ. ಯಾವುದೇ ಸ್ಟೇಜಲ್ಲಿ ಇದ್ದರೆ, ಯಾವುದೇ ಪ್ರೊಫೆಷನ್ಗೆ ಹೋದರೂ ಕೂಡ ಕರಪ್ಟ್ ಆಗಲ್ಲ. ಕರಪ್ಷನ್ ಕಂಡರೆ ಅಲ್ಲಿ ನಾನು ಪ್ರಿವೆನ್ಷನ್ ಮಾಡೋದಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. ಇಷ್ಟು ನಾವು ಒಂದು ಅಶ್ಯೂರೆನ್ಸನ್ನು ನಮ್ಮ ದೇಶಕ್ಕೆ ಕೊಟ್ಟರೆ ಎಷ್ಟೋ ಆಗುತ್ತೆ. ಇಲ್ಲ ಅಂತಂದರೆ ಬಡವರು ಎಸ್ಪೆಷಲಿ ಈಗೇನಾಗಿದೆ ಅಂತಂದರೆ ಸಮಾಜದಲ್ಲಿ ದುಡ್ಡಿರೋರಿಗೆ ಏನು ಕೆಲಸ ಬೇಕಾದ್ರೂ ಆಗುತ್ತೆ, ದುಡ್ಡಿಲ್ದಿದ್ದವ್ರಿಗೆ ಏನೂ ಕೆಲಸ ಆಗಲ್ಲ ಅನ್ನೋ ಒಂದು ಭಾವನೆ ಸಾಮಾಜಿಕವಾಗಿ ಸಾಮಾನ್ಯ ಜನಗಳಲ್ಲಿ ಮೂಡ್ ಬಂದಿದೆ. ಇದನ್ನು ಎರಾಡಿಕೇಷನ್ ಮಾಡಬೇಕಾಗಿರೋದು ನಮ್ಮ ಕರ್ತವ್ಯ. ಇದು ಅಷ್ಟು ಸುಲಭ ಅಲ್ಲ ಮಾಡೋದು, ಕಷ್ಟಕರವಾದಂಥ ಕೆಲಸ. ಆದರೂ ಕೂಡ ನೀವು ಒಂದು ಕರೇಜಿಯಸ್ ಆಗಿ ಒಂದು ಡಿಸಿಷನ್ ತಗೊಂಡ್ರೆ ಖಂಡಿತ ಅದನ್ನು ಪಾಲನೆ ಮಾಡೋದಕ್ಕೆ ಸಾಧ್ಯತೆ ಇದೆ. ಬೇಕಾದಷ್ಟು ಕಷ್ಟಗಳು ಬರುತ್ತೆ ನಡುವೆ, ಯಾಕೆಂದರೆ ಆನೆಸ್ಟಾಗಿರೋರನ್ನ ಆನೆಸ್ಟಾಗಿ ಬಿಡೋದಕ್ಕೆ ಬಿಡೋಲ್ಲ ಜನ. ನಿಮ್ಮ ಪಕ್ಕ ಇರೋರೆಲ್ಲ ಡಿಸಾನೆಸ್ಟ್ ಇದೆ, ನೀವು ಒಬ್ಬರು ಆನೆಸ್ಟ್ ಆಗಿದ್ದಾಗ ಅವ್ರು ಏನಾದ್ರು ಮಾಡಿ ನಿಮ್ಮನ್ನು ಅವ್ರ ಕಡೆಗೆ ಹೇಳ್ಕೊಡೋದಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತಿರ್ತಾರೆ. ಆದರೆ ಪ್ರಿನ್ಸಿಪಲ್ದಾಗಿರೋರು ಕೊನೆಯವರೆಗೂ ನಾನು ಆ ಕೆಲಸನೇ ಬಿಡ್ತೀನಿ, ಬೇಕಾದ್ರೆ ನಾನು ಪ್ರಿನ್ಸಿಪಲ್ ಬಿಡಲ್ಲ ಅನ್ನೋವಂಥ ಮನೋಭಾವನೆ ಬೆಳೆಸ್ಕೊಂಡಿರಬೇಕು ನಾವು. ಅವಾಗ ಮಾತ್ರ ನಾವೇನಾದ್ರು ಸ್ವಲ್ಪ ಅಚೀವ್ ಮಾಡೋದಕ್ಕೆ ಸಾಧ್ಯ. ಅದಕ್ಕೆ ನಮ್ಮ ಡಿ.ವಿ. ಗುಂಡಪ್ಪನವ್ರು ಹೇಳ್ತಾರೆ, ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ, ಹುಲ್ಲಾಗು ಬೆಟ್ಟದಡಿ ಮನೆಗೆ ಮಲ್ಲಿಗೆಯಾಗು ಅಂದರು. ಕಲ್ಲಾಗು ಕಷ್ಟಗಳ ವಿಧಿ ಮಳೆಗರೆಯೇ, ಬೆಲ್ಲ ಸಕ್ಕರೆಯಾಗು ದೀನ ದುರ್ಬಲರಿಂಗೆ, ಎಲ್ಲರೊಳಗೊಂದಾಗು ಮಂಕುತಿಮ್ಮ ಅಂದರು. ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ ನೋಡಿ. ಹುಲ್ಲಾಗು ಬೆಟ್ಟದಡಿ ಅಂತಂದರೆ ಹುಲ್ಲಾಗಿ ಹುಟ್ಟಿದ್ದಕ್ಕೆ ಅದು ಹುಲ್ಲು ಎಷ್ಟು ಸಂತೋಷ ಪಡುತ್ತಂತೆ. ಯಾಕೆಂದರೆ ನಾನು ದನಗಳಿಗೆ ಮೇವಾಗಾರು ಹುಟ್ಟಿದ್ದೀನಲ್ಲ, ನನ್ನ ಜನ್ಮ ಸಾರ್ಥಕ ಆಯಿತು. ಮನೆಗೆ ಮಲ್ಲಿಗೆಯಾಗು, ನಿಮ್ಮ ಮನೆಗೆ ನೀವು ಮಲ್ಲಿಗೆ ಆಗು. ಯುವರ್ ಫ್ರಾಗ್ರೆನ್ಸ್ ವುಡ್ ಸ್ಪ್ರೆಡ್ ಫಸ್ಟ್ ಇನ್ ಯುವರ್ ಫ್ಯಾಮಿಲಿ, ದೆನ್ ಯುವರ್ ಫ್ಯಾಮಿಲಿ ವಿಲ್ ಸ್ಟಾರ್ಟ್ ಸ್ಪ್ರೆಡಿಂಗ್ ದಟ್ ಫ್ರಾಗ್ರೆನ್ಸ್ ಟು ಯುವರ್ ವಿಲೇಜ್, and then your village to the entire town, and then to the cities, and then to the entire country. ಆ ಫ್ರಾಗ್ರೆನ್ಸ್ ಅಂತಂದರೆ ಆ ಒಳ್ಳೆತನ ಏನಿದೆ, ಈ ಆನೆಸ್ಟಿ, ಸಿನ್ಸಿಯಾರಿಟಿ, ಪಂಕ್ಚುಯಾಲಿಟಿ, ಇಫ್ ಯು ಫಾಲೋ ದಟ್ ಇನ್ ಯುವರ್ ಲೈಫ್, ಯು ವಿಲ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ದ ಸೇಮ್ ಫ್ರಮ್ ಅದರ್ಸ್ ಆಲ್ಸೋ. ಯು ವಿಲ್ ಟ್ರೈ ಟು ಬ್ರಿಂಗ್ ದೆಮ್ ಟು ಯುವರ್ ಲೈನ್. ಇದಷ್ಟು ಸುಲಭ ಮಾಡೋಕ್ಕಾಗತ್ತಾ? ಮನೆಗೆ ಮಲ್ಲಿಗೆ ಆಗು, ಕಲ್ಲಾಗು ಕಷ್ಟಗಳ ವಿಧಿ ಬೆಳಗ್ಗೆ. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ರು, ಇದು ಇರೋದಕ್ಕೆ ಕಷ್ಟ, ತುಂಬ ಕಷ್ಟ. ಇದನ್ನು ಅದಕ್ಕೆ ಕಲ್ಲಾಗಬೇಕು. ಎಷ್ಟೇ ಮಳೆ ಬಂದರೂ ಕೂಡ ಕಲ್ ಮೇಲೆ ಏನಾಗುತ್ತೆ? ಕಲ್ ಮೇಲೆ ಎಷ್ಟು ಮಳೆ ಸುರಿದ್ರೂ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ. ಹಾಗೆ ಎಷ್ಟೇ ಮಳೆ ಕಷ್ಟ ನಷ್ಟಗಳು ಬಂದರೂ ಕೂಡ ಕಲ್ಲಾಗಿರ್ತೀನಿ ನಾನು. ಯಾತಕ್ಕೋಸ್ಕರ ನಾವು ಇದನ್ನು ಮಾಡಬೇಕು ಅಂತಂದರೆ, ನಮ್ಮ ಜೊತೆಲಿರೋರೆಲ್ಲರೂ ನಮ್ಮ ಸಮಾನರಾಗಿಲ್ಲ, ಅವ್ರನ್ನೆಲ್ಲ ನಮ್ಮ ಸಮಾನವಾಗಿ ಮೇಲಕ್ಕೆ ಎತ್ಕೋಬೇಕು. ಬೆಲ್ಲ ಸಕ್ಕರೆಯಾಗು ದೀನ ದುರ್ಬಲ, ಹೂ ಈಸ್ ಇನ್ ನೀಡ್ ಆಫ್ ದಟ್. ಯಾರಿಗೆ ಅವಶ್ಯಕತೆ ಇದೆ ಅವರು ಕೊಡಬೇಕು, ಅವ್ರಿಗೆ ಸಹಾಯ ಮಾಡಬೇಕು. ಬೆಲ್ಲ ಸಕ್ಕರೆಯಾಗು ದೀನ ದುರ್ಬಲರಿಂಗಿದ್ರು. ಆವಾಗಲೇ ನೀನು ಒಂದು ಸಾರ್ಥಕವಾದ ಜೀವನ ಮಾಡೋದಕ್ಕೆ ಸಾಧ್ಯ. ಎಲ್ಲರೊಳಗೊಂದಾಗು ಮಂಕುತಿಮ್ಮ. ಎಷ್ಟು ಚೆನ್ನಾಗಿ ಬಂದಿದ್ದಾರೆ. ಎಲ್ಲ ಪ್ರೊಫೆಷನ್ಗೂ ಕೂಡ ಇದು ಆಪ್ಟಾಗಿ ಅಪ್ಲೈ ಆಗುತ್ತೆ, ಯಾವ ಪ್ರೊಫೆಷನ್ ಆಗೋದಿಲ್ಲ. ಸೊ ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಫಾರ್ ಪಾರ್ಟಿಸಿಪೇಟಿಂಗ್ ಇನ್ ದಿಸ್ ಪ್ರೋಗ್ರಾಮ್. ಥ್ಯಾಂಕ್ ಯು ಫಾರ್ ದ ಆಪರ್ಚುನಿಟಿ.
Good morning everyone. I, Tripti, on behalf of CMI University School of Legal Studies and the entire fraternity of the institution, first of all would like to extend a hearty thank you to our Chief Guest, Justice Shri K.N. Phaneendra, who spared time from his busy schedule to grace the occasion. Today we had an opportunity to hear your thoughts, sir, and thank you for giving all of us insights of Lokayukta institution. Thank you, sir, and thank you for giving all of us insights of Lokayukta institution and its role in curbing corruption and other malpractices in public administration. We got the opportunity to understand the mechanism and functioning of Lokayukta and Lokayukta. Your lecture will surely encourage us in our future endeavors. Your thoughts have enlightened our minds and have shown us a new path. I would also like to thank our beloved Dean Professor Dr. T.R. Subramanya for being the catalyst that stimulated us to do our best and for always supporting us and providing us with opportunities to conduct such informative guest lectures. Thank you, sir. I'm also immensely thankful to our director, Dr. Vijay Praneshwaran, for his efforts. Thank you, sir. Next, I would also like to thank our teacher, Dr. Vandana Rajput, for her contributions in making this event a great success. Thank you, ma'am. I would also like to thank the people who work behind the scenes to make this event happen, our technical arrangement team. Thank you. Last but not the least, I would like to take a moment and thank each one of you for your enthusiastic presence. Thank you, everyone, and have a good day. Thank you.